Now we'll commence on our second session under the title Contributions of the United Nations to Ocean Governance. And now it's time to welcome our panelists for session 2. This session will be moderated by His Excellency Lee Jae-hyung, Judge of the International Tribunal for the Law of the Sea. Judge Lee, the floor is yours.
Good afternoon, Excellencies, ladies and gentlemen. It is my great delight to see you here in ICLS. And on this auspicious occasion of the 10th anniversary of ICLS, even after the very sumptuous lunch, you are keeping seats, and we are all witnessing that ICLS is taking firm root in the law of the sea community. The theme of this session is Contributions of the United Nations to Ocean Governance. This year marks the 80th anniversary of the United Nations. With all its shortcomings, there is no denying that the organization has played a central role in shaping international law, diplomacy, humanitarian aid, and peacekeeping over the last 8 decades. The preamble of the UN Charter provides, quote, to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained, unquote, as one of the ends of the United Nations. This rule of law has also served as the supporting base and connector of the other ends of the UN, namely the 3 pillars of peace and security, human rights, and development. Against this background, we would like to explore how the United Nations has made what contributions to ocean governance specifically. Probably the first thing that comes into our mind in this context might be UNCLOS, the United Nations Convention on the Law of the Sea. As we are all aware, UNCLOS and its 3 implementing agreements were negotiated under the auspices of the United Nations. We are also familiar with the bodies established by UNCLOS, such as ICLS, ISA, CLCS. Furthermore, every year there is a meeting of states parties to UNCLOS, and in the General Assembly of the United Nations, adoption of Oceans and the Law of the Sea resolution and Sustainable Fisheries resolution, respectively. Informal consultative process on oceans and the law of the sea. Although not annually, we also have review conference of fish stocks agreement, regular process of World Ocean Assessment, UN Ocean Conference, and so on. In addition, ICJ, as the principal judicial organ of the United Nations, has formulated considerable and influential jurisprudence so far that impacts ocean governance, including that on maritime delimitations and recent advisory opinion on climate change. We also have discussions going on in the Security Council and Economic and Social Council, not to mention the significant role of Secretary General and Division for Ocean Affairs and the Law of the Sea. Specialized agencies such as IMO, FAO, UNEP are also working to complement and improve the existing ocean governance in line with changing circumstances, as was addressed by President Haida this morning. Of course, I did not forget the important contribution of ILC to the progressive development of international law and its codification, including the law of the sea. This afternoon, we are blessed with the presence of 3 incumbent ILC members on the panel, in addition to an eminent scholar and a competent practitioner. We do not have sufficient time to deal with all the elements that I refer to, and I believe some of the elements will be covered tomorrow in session 3 and 4. Before I invite the first speaker, I'd like to ask for your kind understanding. The third speaker, Professor Kunoi, was not able to make it to Seoul due to some personal reasons. While we are sorry about the absence of Professor Kunoi, in return for your kind understanding, we'll have 5 additional minutes from each of the panelists who will share their wonderful expertise and invaluable insight. Now, without further ado, I'd like to invite Professor PAPARINSKIS to make his presentation. Professor Martins PAPARINSKIS is Professor of Public International Law at University College London and the chair of the 76th session of the International Law Commission. Professor PAPARINSKIS, the floor is yours.
Thank you very much, Judge Rhee, for the very, very kind and generous words of introduction. Your Excellencies, ladies and gentlemen, judges, ambassadors, colleagues, friends, students, the visible College of International Law. It is such a privilege to be before you today. And I will speak, as Judge Rhee said, about the contribution of the International Law Commission on these matters. So to some extent, my presentation will be structured in various ways around the important propositions that were debated in the panel before lunch. I will address 3 points. I will first say something about the historical contribution of the International Law Commission. Now, International Law Commission was not the moving power behind the third conference that led to the conclusion of UNCLOS, but it provided the backdrop against which modern international law of the sea was drafted. And I thought that it may be helpful, before delving into the finer points of sea level rise in relation to international law, which will be my second point, to also sketch the broader historical background, to remind ourselves of what the Commission may do and why things that it does may not always succeed immediately in legal or political terms. And the third point will be a broader one, perhaps stepping beyond the International Law Commission to reflect on a variety of ways of ensuring coherence of this field beyond what one might describe as institutional fragmentation. So history, the particular very important topic of sea level rise in relation to international law that concluded just this year, and the broader picture of coherence in many institutional islands. So what did International Law Commission do on law of the sea? This is, historically speaking, something at the very beginning of the work of the International Law Commission. The International Law Commission lags 4 years behind the United Nations, 80th anniversary of United Nations. This year, as Judge Rhee said, 76th session of the International Law Commission. So 1950, those are the very early years of the Commission, and Special Rapporteur Francois, with good experience of how not to codify international law of the sea from the 1930 Hague Conference, takes the lead on the matter for 7 years on the basis of the draft articles concerning the law of the sea. There is the first United Nations conference on the law of the sea, as the result of which, departing from the proposal of the ILC to draft a single instrument, the Geneva Conference comes up with 5 instruments, 4 predominantly substantive, covering 4 substantive tranches of law of the sea, and the 5th, the optional protocol concerning the compulsory settlement of disputes. And as you see from the glimpses of numbers of ratifications in the brackets, different instruments fare differently. And of course, those numbers don't seem impressive if we measure them against the 193 states that United Nations has now. But in 60s and 70s, the number was significantly smaller. So what do we have there? Three instruments faring reasonably well: territorial sea and the contiguous zone, particularly high seas and also continental shelf, and two much less so. What is the relevance nowadays? Well, as a matter of treaty law, not great. UNCLOS supersedes Geneva Conventions between the parties. There are some parties like Colombia and United States and Israel, which do fall within that category, but predominantly these are matters as a treaty law of historical interest. So what do we make of that? Well, first, I think perhaps worth noting in light of the increasingly narrow and focused topics of the International Law Commission, just the sheer ambition, taking on the entirety of law of the sea at a point when it was being shaped by a state practice in various ways. So think of the historical foundations at the time of continental shelf law and the much more troubled in the early years law of fisheries. Nevertheless, a commission tackled the issue and proposed what in retrospect seems the correct and preferable choice, a conclusion of a single instrument with compulsory dispute settlement. To some extent, one might say the solution that UNCLOS adopted later. We are now looking at the ILC work as a reflection of traditional post-World War II law of the sea, very influential still in some respects, as one can see when reading side by side the relevant Geneva Conventions and the parts of UNCLOS, so on high seas in particular, as we saw in the International Law Commission when discussing the topic that my colleague and friend, Special Rapporteur Savadogo, is a lead on: piracy. In other respects, controversial, but even on those points that are controversial, in many ways going to issues that have been at heart of the legal and policy debate in the following years and decades. So the idea of cooperative approach in relation to fisheries is reflected to some extent in the fish stocks agreement, and the compulsory judicial settlement is also there. It is not entirely irrelevant in contemporary practice, but I think reflecting the intuition that one had from the numbers of ratifications, we mostly see it in the context of those fields where the ILC work was most influential in capturing and influencing international law. So high seas as well as territorial sea and a contiguous zone. And again, the work on piracy shows how significant ILC was in shaping and in some respects, one might even say, constructing international law of the issue. So that is the historical perspective. Let me now move to a much more contemporary issue: sea level rise in relation to international law, mentioned in the previous panel, and for which the final report was adopted just this year. So for the very, very careful readers who want to know absolutely everything about the final report, you might want to have on your desks when reading it the final report itself, which is included in Annex 1 of this year's report of the International Law Commission. Chapter 4, which summarizes the debate within the study group in relation to adoption of the report. And finally, for true pedants, records of meetings 3,719 and 20th, which were the adoption in the plenary of the report. The reason why I put up here the as it were, congratulatory language for the excellent co-chairs and the International Law Commission is to note the strength with which the Commission endorsed the final report of the study group. So here, the public plenary record notes the point raised by the Commission member, Mr. Forteau, contrasting the language used here with that used regarding the 2006 study group report on fragmentation, where the Commission merely took note of that report. Here, the endorsement is a much stronger one. So the Commission adopted the final report of the study group. Also, the public discussion in the plenary shows very little disagreement among members regarding substantive propositions here. There are certain drafting issues raised, but to a significant extent, these reflect the consensus within the study group, which was this year constituted of 28 members, and the broader Commission. So this is coming with a rather strong backing of International Law Commission as an institution. What did the study group look at? Well, in terms of framing, the study group took as a given sea level rise due to climate change as a scientific fact by reference to scientific studies and reports, and took it as an intellectual lens to consider the implications for three distinct topics of international law: law of the sea, statehood, and issues related to the protection of persons affected by sea level rise. The format is study group, so this is not the more usual format of the International Law Commission, where a special rapporteur prepares a report on the topic, which is then subject to a public discussion in the plenary, closed discussion in the drafting committee in relation to provisions, and then again a public discussion of adoption of commentaries. Study group proceeds in a different way. It proceeds by initially the production of issues papers by chair, or as in this case, co-chairs of the study group, then a closed discussion, a summary of which is reflected in the relevant chapter of the report, and that is essentially it. So we do not have a third discussion in the plenary as one might have for the commentaries in the usual format. And this, I suppose, to some extent makes it externally less visible where the precise lines of difference are, although the summary of the records, the summary of the discussion does indicate it to some extent. Certain topics were included, certain topics were excluded, so causation, responsibility, and liability were excluded from the topic of discussion. It doesn't mean that it is something that the International Law Commission cannot address in principle. It simply means that it is not something that would be addressed here. And I note that this year in the sixth committee discussion of the report, a delegate by Egypt pointed out that issues excluded as a matter of this topic may be considered when the Commission considers compensation for the damage caused by wrongful acts more generally. What is the character of the final conclusions? This is an issue raised in the plenary discussion by one member, to which who pointed out that the language in the report itself speaks about this being a summary of the views expressed in the study group. The original draft report prepared by the co-chairs spoke of the language of these conclusions not being normative. and co-chair explained that this is, after considerable discussion, the idea of summary of the views expressed was viewed as the most, as the aptest in that regard. In relation to the first topic, the argument that is put forward in the conclusions is that during the conclusion of UNCLOS, climate change-related sea level rise was not viewed as an issue of concern. At the same time, UNCLOS and its integrity are of fundamental importance, so that was also one of the elements in the study group mandate, not modifying UNCLOS. And within UNCLOS, it was noted that there were no rules that require updating of baselines to reflect physical change, that the shift of baselines and the outer limits of maritime zones would be particularly inequitable in this situation, and that there is widespread support for the views traditionally expressed in the 2021 Pacific Island Forum Declaration regarding essentially non-ambulatory character of baselines in this context. So this was a point to which Sir Michael alluded to in his intervention to the panel before lunch. Essentially, the traditional position may well have been that this is an ambulatory approach. The question of how one might address it, Sean Murphy, a former member of the International Law Commission, wrote in his scholarly capacity that there were a number of ways of thinking about it, whether fixing baselines or perhaps fixing the outer limits of maritime zones, or perhaps disaggregating the relevant rights and obligations. But so the language here essentially went in the first direction of fixing baselines and the outer limits of maritime zones. The second broader theme relates to statehood, and here the question is whether statehood is affected by possible submergence of land territory, or more likely in the closer term, partial or total uninhabitability of particular states. And there were a number of considerations that the Commission study group identified to support the maintenance of statehood in these circumstances and the entitlement for states to take measures available under international law, so within the framework of existing international law. The third theme, and that was in terms of legal methodology a somewhat different challenge from the previous two, that one could identify the relevant legal issue with considerable certainty, so either a particular proposition regarding a drawing of baselines and maritime zones in UNCLOS and reflective customary international law, or customary international law of statehood. Human rights is, as the language was chosen, fragmented and also not specific to the particular challenge. And in this particular circumstances, what Commission did, it identified certain parameters such as human dignity and other considerations that could be relevant in addressing these challenges. And in the broader debate in previous years, it seems that to a considerable extent, this draws upon the propositions identified in the Commission's earlier work on protection of persons in the event of disasters. So similar language that you see here would also be occurring in that setting. Variety of practical tools were flagged, and in particular, international cooperation was noted. One member raised the question in the plenary adoption of the report of what sort of obligations were those that were at play in the context of cooperation here. So would they be reflective of common and differentiated responsibilities, as in the climate change regime? And the co-chair, Galval Teles, explained that this was not an issue on which there was a consensus within the study group. So a more general language of cooperation is included here. The three subtopics are legally distinct, but also interconnected, in that taking a position on law of the sea may have implications regarding statehood, and position taking regarding statehood, and in particular on nationality and statelessness, may have implications on protection of persons. So they are distinct, but to be considered together. And that is the point noted here as well. Finally, what is to be done? Possible ways forward. And there are two points noted here. The first relates to, as it were, dealing with instruments that we have. And we have here three sub-paragraphs. The first relation to law of the sea, the second to in relation to other related matters under UNCLOS or other settings, and finally regarding protection of persons. And here, from sort of the broader background of discussion, 2 points to be flagged are perhaps in relation to subparagraph A, so essentially interpretation of existing instruments and rules. There is language in the summary of the debate in chapter 4 which suggests the importance of stressing that there are both elements of interpretive hooks that one can find in the UNCLOS regime as it exists, and also subsequent practice that could be brought as relevant. So it's neither one nor the other, but both. And in relation to subparagraph B, there was a degree of a discussion regarding the connection between interpretive statement and subsequent agreement, so what we currently have as or. And one member suggested amending it to and the result of the discussion was that it was important to maintain or to identify maximum possible flexibility, that different sort of instruments may be adopted in different settings. And then there are things that could be adopted in a variety of settings by General Assembly, by other institutions in developing new instruments. So what you do not have here is development of new instruments regarding law of the sea as such, in line with the broader theme of operating within the limits of UNCLOS and not moving beyond it. So, few concluding thoughts. So how does one think about coherence beyond institutional fragmentation? Of course, posing questions in these terms may be thought to be questionable in its own terms, because it assumes a sort of prelapsarian point where fragmentation did not exist. As we heard from the first panel, there were many institutional settings and fields where these matters are discussed. ILC, I think, is a particularly helpful one, nevertheless, for the broader coherence to be ensured, both as a matter of substantive reasoning and as a vehicle through which states can express their views. And I think that that was the position both in the 1950s, as one can see from the discussion in judgments such as Peru and Chile, and particularly in relation to sea level rise. But this is, of course, not the only relevant setting, and other speakers like Professor Klein noted other matters as well. International courts and tribunals are particularly important here, and thinking of how, from the ILC perspective, they can add to the discussion, I draw upon the ongoing work on subsidiary means for determination of rules of international law, which has identified a variety of parameters by reference to which one could evaluate the weight to be given to particular judgments or advisory opinions, which in the view of ILC both fell under judicial decisions. And so that would provide the explanatory rationale for the considerable weight given to the advisory opinion of ICLS by the International Court of Justice. Correctly, in my view, although I have to declare an interest that that was a point that I argued for Latvia, making precisely that point. From the perspective of ILC, and that will be my final minute, it was felt that the ICJ was quite salutary regarding the outputs on this particular issue, an explicit reference to sea level rise, although regarding the particular issue of baseline, so perhaps not necessarily drawing all the broader conclusions that the ILC did. A passage regarding statehood, which may seem briefer than what the Commission did, but in many respects one might think it captures accurately the very early stages of the development of the law on the question, and human rights, where in a similar way the Court took note of the developments on the matter. And that is all, Judge Ree.
Thank you, Professor PAPARINSKIS, for the very comprehensive introduction to the work of the study group.